The theme of this session is gender and disability inclusive legislation. My name is Suzanne Doyle-Guillou, and as Jafi also mentioned, I have recently joined Validity as an inclusion advisor. I am a white woman with short curly brown hair, and I'm wearing a black dress, and I am a neurodivergent person. This session is going to explore how inclusive legislation can address barriers in justice systems, particularly for women and children with disabilities who are at risk of violence. We'll hear about practical approaches from various contexts, including the role of intermediaries in criminal justice proceedings, a case study of legislative change in Malta, and the work of rights protection officers in Iceland. Our session features the three experts that we have, that you have in front of you on the screen. Each presentation will last in and around 15 minutes, and then hopefully we will have time for questions afterwards. So let me introduce our speakers for today before we begin their contributions. First of all, we have Maria Krasteva, a legal expert with the Network of Independent Experts. Maria will discuss the role of intermediaries in criminal justice proceedings and how they can reduce communication barriers for persons with disabilities. Next, we'll hear from Sara Rocha, the Vice Chair for Women's Rights at the European Council of Autistic People. Sara will present a case study from Malta, sharing insights into successful legislative change that enhances access to justice for persons with disabilities. And finally, we have Eliona Gjecaj, a PhD candidate at the Centre for Disability Studies at the University of Iceland. And Eliona will speak about the role of rights protection officers in Iceland and their contribution to making justice systems more inclusive. So that's enough from me. I'm very happy to hand over to our first speaker, Maria Krasteva. Thank you, Maria.
Hello, everyone. Can you hear me well?
Yes, we can hear you well. Thank you, Maria.
Okay, perfect. First, thank you for the invitation, and I'm very happy to be part of this important work that we are all doing in the direction of rights of persons with disabilities, and particularly in the light of my presentation, particularly the access to justice. So today, if you can please share my presentation, I'll be speaking about justice intermediaries. Should I play it and share the screen, or you will do it? Okay. Thank you. Yes, are we ready?
We appear to have lost your presentation for a moment, Maria. Let's just...
Yeah, that's fine.
Let's just wait if we can see if we can get that back on screen.
It's a very brief presentation. I'm not much of a PPT person, but this helped me organize my thoughts.
Just bear with us a moment there, Maria, please.
Sure.
We can see that now.
Okay, thank you. So about justice intermediaries, so this is one of the names that they call these experts. In some countries, it is called communication facilitators, in others, communication assistants. But in any way, these are who they are. These are independent experts. If you can just go to the first slide, please. These are independent experts who facilitate the communication between the person with communication needs and the justice authorities or other actors. That's traditionally what the justice intermediary mean. Around the world, there's already around 17 countries that have already launched the role or are trying to do it, like Japan and Taiwan right now. But maybe UK, United Kingdom, meaning England and Wales, are the countries that have the most long history with the role, having from I think 2008 having legislated explicitly the role, having this certified trainings, and have this long history of justice intermediaries being part of their justice systems. It was originally, they were originally designated to help vulnerable persons, particularly children, and persons with disabilities in the criminal justice cases. So other countries that also have the figure, just like I will just list some of them. The role is also familiar in Spain in the past years. Also New Zealand, Australia, in the States, in the United States, Vermont is one of the states that also kind of like promote the role. We also have Bulgaria, of course, our country that recently we are trying to launch to pilot the role, and now this is just like a very brief introduction. And now I will share with you more about our story with the role and how about the Bulgarian experience and what we went through to kind of like introduce a role which is still unfamiliar, unknown to our systems, very, very new. Not only in terms of legislation, but also in terms of our traditional practices and concepts of the justice systems. So what we did in Bulgaria last year in 2023, we did this training of 5 speech and language therapists to do the role of the intermediaries the way it was set in UK mostly. We kind of like tried to copy their good practices as the country with the probably longest tradition. So what we did this training of the speech and language therapists, and now we kind of like started talking about it. If you can go to the next slide. Yes, thank you. We had this trainer, Paula Becken, who is a certified justice intermediary in England. She came to Bulgaria, did the training, and then we have some sessions online. So it took like a half a year to finish this training. And we kind of like focus on the criminal cases, and also on the criminal cases, but for all parties in the justice proceedings, meaning defendants, victims, as well as witnesses. And lacking the legislative framework, it could be a negative, but also kind of like a positive for us, because we got this blank field, white paper, a blank paper, and we were able to really sit and think about how we really want this to work one day when we got the framework. So we definitely have our helpers from the UK, also from New Zealand, which also have, especially in the face of Sally Ketch, also have these very good progressive practices as communication assistants. We also have the help of Mexico, which kind of like here in Bulgaria, elected the legislative framework, but the legislative grounds, but still we're doing it for the many years now. So with their help, we kind of like managed to frame what we would like to have here in Bulgaria, and it is this. A very simple working process. When we have a vulnerable person, a person with some kind of communication needs, and we have our police, which person is has some kind of interaction with the criminal justice system, either with the police at the very first stages of interviews and any kinds of interactions, or in the court already at the court stage. When such a person is identified by the justice authorities, they can reach out to us, to the communication facilitators. That's how we call it here in Bulgaria, communication facilitators. They can reach out to us, and we can start the working process, which is to first meet with the person, the communication facilitator, or the justice intermediary, like they call it in England. Reach out the person, meet in person, and do this assessment of the person's communication skills, but also, and very important, also the barriers of the justice system that this very person could struggle with in order to participate effectively in the proceedings. So first, the communication facilitator do this report, do this assessment, and afterwards it made the communication facilitator writes a report to the either police, the police investigators, or the court, to the judges, in which report the communication facilitator gives recommendations for the communication specifics and how to communicate effectively with the person. In the end of the report, the communication facilitator usually says either it will be needed, he or she will be needed, the expert will be needed in real time to support the person, or not, or not, meaning that the justice actor, the judge, or the police doesn't really need, wouldn't really need the expert, and it can very well handle the communication following the recommendations given in the report. So if, of course, a recommendation is to participate in real time, that's the final stage. And if, of course, the judge or the police allow it, because there is the final conclusion, the final resolution, whether a communication facilitator will be appointed at the proceeding or not. So if that happens, the expert participates in real time, supporting physically the person in the premises, goes to court, goes to the police station during interviews or hearings. So this is the simple explanation of the process. The very principles that this this whole process follows are simple. There are quite a few, but I'll just mention a couple of them. Consent, meaning that for assessing the person's communication skills, we first need, the communication facilitator first need to receive the consent of the person. And of course, if the intervention continues in real time, again, we need the consent of the person, whether he or she really wants this expert to support, to assist them during the proceedings. So 2 stages of consent. And another one, impartiality, and very important. Impartiality is kind of like the basis of the work of the communication facilitator. That is also one of the reasons that speech and language therapists are kind of like considered the most appropriate specialists here with this particular background, because they only focus on the communication. In the very particular case, they don't give any other evaluations of the process, of the legal part of the case, of the facts, or any of this. Only communication. Okay, if you can, okay, I can, no, you can go to the next slide, please. And these are some very, very important resources here, because I'm sure there's a lot to be read about the role and to be explained. So first, you can see here a link to a very short video explaining the role of justice intermediaries. It was made some years ago by the colleagues in England and Wales. But it is, I usually, we also got these Bulgarian captions, so I usually use it here when we inform on the role, use it as a training video. So it is a very good one. You can watch it and have some additional perspective on what's the job of the intermediaries. And then the second point, that's the Bulgarian website. Here we gather our basically our expertise, what we are doing here in Bulgaria, a very brief, again, framework of how we work, the working process, some of the things that I've already explained, and of course, very important, make a referral, the way that you can make a referral and contact communication facilitator. And the third website, this is a resource that I highly recommend for anyone in any country that would like to get a closer glance at how the justice intermediaries work, and how they can eventually introduce them or start thinking about introducing them in their systems, national systems. So this website, that is something that is made by a hub, an access to knowledge hub, and it includes useful resources, not only on the maps, on the map of all the countries that have already implemented the role, but also have these pieces of legislations that they use to ground using this very this kind of like new figure expert, but also you can find these modules explaining practical questions like identifying which person can really need such an expert, and things like that. So some final words. I hope I have another minute for the final words.
You do have 1 more minute. Thanks, Maria.
Right, thank you. So justice intermediaries, communication facilitators, these are, this is very important. These are all experts that can assist the process of accessing justice by vulnerable persons, okay? But then this we have at the stage of police, at the stage of court, for example, when something already had happened, and we managed to, and the person somehow managed to enter that stage. But it will be hypocrisy to say that these experts are some kind of like a painkiller, or that they can, you know, resolve all the problems. What is very important to keep in mind, the systematic of problems when we talk about vulnerable persons and justice systems, and that first we need to think about prevention. We need to think about other barriers that actually prevent even more, the vulnerable persons to enter, to access justice. And for example, with the case in Bulgaria, we can even start with the question, why we do not believe children and women with disability when they say that they experienced violence. Okay, that's for me. Thank you very much. I will stay here a little longer for questions.
Thank you so much, Maria, for that very informative presentation. We'll now move on to our next speaker, Sara Rocha.
My name is Sara Rocha. I'm Vice President of the European Council of Autistic People and Vice Chair of the Women's Committee for the European Disability Forum. I think I have also a presentation. Not sure if, would you, yeah. Okay. I'll be talking about a good practice example on the criminalization of forced sterilization in Malta. You can pass it, please. So forced sterilization is an eugenic practice. It's a violation of sexual and reproductive rights and in health, and it's a form of violence against women. It is linked with sexual exploitation, and it's very important that we change the laws across the EU to make sure that it is criminalized all across the European Union. But unfortunately, at the moment, only 10 countries criminalize forced sterilization as a distinct offense, and 11 countries do not allow forced sterilization of persons with disabilities, but it is not criminalized. 3 countries, including mine, Portugal, Czechia, and Hungary, allow it in minors. This is a graphic. It's a little bit updated with one more country that criminalize forced sterilization, but you can see more information on the European Disability Forum report of 2022. If you can pass, please. So in terms of the EU legislation, forced sterilization is prohibited by the Article 23 of the United Nations Convention of the Rights of Persons with Disability. It is also on Article 39 of the Istanbul Convention. And however, there are no real mechanism for enforcement or sanctions. So even when there are CRPD reviews and forced sterilization is identified, there's really no consequences of accountability for this practice to be implemented in Europe. Recently, we lost a very big opportunity to criminalize forced sterilization across all of member states. through the Directive on Combating Violence Against Women. We advocated constantly to ensure that it was there, and European Parliament included that, but it was removed from the directive on the assistance of the Council of the EU, and we lost this very, very big opportunity to criminalize this practice all across Europe. Okay, Jane, please. Thank you. So let's talk about the Malta example. Malta became the 10th country to criminalize forced sterilization in the EU recently. And I wanted to share a little bit of how it was done, because I believe it is a very good example of including perspectives of women and girls with disabilities. So what happens a lot around forced sterilization is there's very limited research on how and why women and girls with disability are being sterilized. As such, the Malta government involves the voices and lived experience of disabled-led organizations and disabled advocates, including survivors of forced sterilization, in writing the law. Because there's so little information, we basically have to gather lived experiences, information on what institutions are reporting, what parents, carers, healthcare providers are, and especially survivors are reporting on how and why these women are being directed to be forcefully sterilized, to understand how we can ensure that that law covers everything to protect them. So thank you. So this is just some examples of the things we found when we were talking to carers, people, institutions, but especially survivors and women with disabilities. Some of the reasons that kept showing up for sterilization was carers and family members concerned about abuse in pregnancy and believing the person couldn't be a parent. Obviously, this is not what happens. It doesn't prevent abuse. It's actually connected with sexual exploitation and might lead abusers to target that person because they know that that person will not produce proof of that abuse as a baby. And in terms of, it's very connected with incapacity and belief that persons with disabilities cannot be parents. Institutions which request it as a standard for acceptance into their facilities. So we had several cases where to be institutionalized and being the only service available for family members and carers, it was kind of a requirement, or at least a suggestion that that would happen. And they would feel compelled to, because it was the only option that they had instead of having community services. Medical professionals suggesting to carers is the best option. In Portugal, we had a situation of a 14-year-old girl, autistic girl, where her mother was advised to sterilize her because it's just easier because there are targets for, these kids are targets for abuse. And so this is, obviously this is medical professionals. This mother did not listen to them, but there are going to be carers and family members that do not have more information, and they're going to trust and believe their medical professionals to make the best decision for their child. And this might lead to more forced sterilization. And finally, menstrual management or to facilitate care. We had a case, we found a case of a woman that was sterilized because she left menstrual blood in the mattress of one of her family members, and that's why she was forcefully sterilized. This is some of the reasons. We found more, but we wanted to ensure that we did a little bit of research on how this is happening. And finally, what type of consent, what is happening around consent. So in terms of consent, countries with substituted decision-making in legal capacity are allowing legal guardians to give consent, carers, institutions, but not only. Portugal, they have a law that was implemented not that long ago, for supported decision making. However, this is not in practice being actually implemented. There's a recent research that showed that most people were still getting restricted on parenthood that were under this legal capacity law, and some of them even couldn't vote. So this, even the ones that are being changed to actually match the CRPD, that doesn't mean that practically in the country this is actually happening. And we have reports actually that in Portugal, legal guardians are not having to report to court or having to go through the proper legal system to forcefully sterilize. As they are legal guardians, they just going to the doctors and saying, we want to forcefully to sterilize our person with disabilities, and the doctors are doing that, which technically it is illegal in Portugal, but it's still happening. We also found women that were pressured into consent or made to believe their disabilities would not allow them to be mothers or parents. We found, we have an autistic advocate, Cristina Paredero, that's been very spoken against for sterilization. She was sterilized when she was 18, and she was pressured by her family because they convinced her that she couldn't be a mother because she's autistic. Not being fully or clearly informed of what the procedure will do. We have situations where they were aware that the procedure is being done, but they were not aware of the consequences of that procedure. And finally, not being informed at all. There was women that were thinking that it was an appendectomy, or that they were just for another surgery, and they had absolutely no information of what actually they were getting through. If you can pass, please. So what we did in Malta, and this is a big effort, the law was constantly reviewed, and we as women and girls, women with disability, we were in constant possibility of review to make sure it would finalize as we would want it. So it says the surgical removal or disablement of a minor or adult's reproductive organs without that person free and informed consent leading to sterilization leads to a person being guilty of enforced sterilization and being liable to imprisonment from 5 to 9 years with the possibility of a fine. Some of the points is there is no substitution of free and informed personal consent further to the convention, and accomplices are also covered under this offense. And this is very important because it's not just the doctor that it is practicing this, is all of the people that facilitate, that pressure and coerce the person into having this procedure being done. The punishment increases by 1 degree up to a maximum of 12 years when the commission of such crimes involves also the use of force, deceit, fraud, bribery, false pretense, coercion, or threats. And finally, the court can additionally impose fines and compensations for the victim. So this guarantees that consent is only by the person informed, and that the accomplices are also punished in case that there are more than one person pressuring for this type of procedure. You can pass, please. So what does free and informed consent means here? Consent reflecting the will and preference of adult person freely given directly by said adult person in respect of a surgical procedure that might undergo. It was given after said adult person has been provided with prior information in respect of the purpose and nature of the procedure, as well as its consequences, risks, and alternative options thereto, in a manner that is appropriate, accessible, and easy to understand for that adult person, including as necessary through non-conventional methods of communication and access to independent support from third parties. It can be withdrawn at any moment prior to the procedure following its initial having been given, with said possibility having been likewise communicated to the adult person alongside the information indicated above. So in case the person is unable to give free and informed consent, no other person shall be able to substitute said adult person's free and informed consent for the purpose of sterilization. So we ensure that only the person that actually needs to give consent is able to and permitted to give it. If you can pass it, please. So is there an exception? Yes, there is an exception to this provision that is not performed with the purpose of achieving enforced sterilization in terms of this article and would not have been otherwise deemed medically necessary by one or more medical professionals in accordance with the applicable standard of care, which is standard following established medical practice. Follows established medical practice with regards to the granting of informed consent by the patient in terms of the legislation. So in a summary, what this means is that there is an exception in case there is, for example, the life of the patient that is in case. So there are situations, for example, during birth, that a woman might have a hemorrhage and the uterus might have to be retrieved, or something that will make it more difficult for fertility and reproduction. That if it is for life-saving reason, then the doctor is allowed to do it, but there have to be a specific reason based on medical and established medical practices.
Sorry to interrupt you, Sara, but we have about 1 or 2 more minutes, please.
Okay,
Thank you.
I just pass it and I just conclude now. So this, we need further research to understand how and why sterilization is being forced upon women with disabilities, and to ensure that laws go to actually stop it. We need legal capacity laws need to shift across the EU to support it, decision-making to fight the human rights violations against women with disabilities, sexual and reproductive rights, including forced sterilization, contraception, abortion, and others, as well as the provision of inclusive and adaptive support. As we know, it's not just shifting the laws, but is also ensuring that in practice, they are actually being implemented as well. And finally, inclusive legislation that impacts the lives of people with disabilities, especially regarding violence against women, need to not only involve the disability community to ensure it's fit for purpose, but we need to lead it. And I'm finished here. Thank you.
Thank you so much, Sara. Thank you for that really stimulating and interesting contribution. And I was particularly struck by the key role of the disability community itself in achieving that law reform in Malta. We're going to move on to our final speaker for this session, and that's Eliona Gjecaj. So I will pass over to you, Eliona.
Thank you. Can you hear me okay?
Yes, we can hear you really well. Thank you.
Yeah, I do tend to speak quite fast, so if I'll try not to, but if I do, please let me know. Since you've shared everybody's presentation, do you mind doing that for me too? Just to keep it quicker. So as Susan said, so I am a PhD student here in Iceland, and my research focuses on access to justice for disabled women who have been subjected to gender-based violence. I'll be talking to you today particularly about the role of rights protection officers, but want to highlight that at the bottom of this slide you have my email address if you like to continue further on the conversation from today, or you have any particular questions. So yeah, please move on to the next slide. So just briefly before I move on to the role of rights protection officers, or as I abbreviate them, RPO, just to say, so my PhD is part of a European project, DARE, so Disability Advocacy Research in Europe. It's based here in Iceland, and as I said, focuses on the voice and gathering the experience of disabled women and of those supporting them throughout detection, report, investigation, and prosecution of violence. It employs a human rights approach and also qualitative methods, that particularly being interviews, document analysis, and field observation, which otherwise were court observations. And next slide, please. Yeah, just so you have an idea, here's 3 groups of participants that I interviewed. So first, there were 16 disabled women with different ages, different impairments, living across Iceland and so on. And of course, as you'll come to see, with different types experiences of violence. The second group of participants consisted on professionals, those supporting women to report, such as the rights protection officers, staff at support centers, but also professionals from the justice system, such as police, lawyers, prosecutors, judges, court-invited special judges, and so on. And there was 15 interviews with this group, and the final third group was mostly for background information. There was 5 interviews with experts on violence, on the Icelandic justice system, and of course in disability. So next slide, please. Here there's this graph. I have practically put together all the findings of my research as I am towards the end, or as the PhD community, we like to say, I kind of see the light at the end of the tunnel of the PhD. So in this graph, I'm reflecting, as I said, I interviewed 16 disabled women. And part of my data set, I also included 2 life stories of 2 women who had published their experiences of violence as part of my document analysis. So in total, this graph reflects the experiences of violence of 18 disabled women. As I said, those have different impairments, and in the little figurines of women, I have tried to capture abbreviations of the impairments. For example, visual impairment, autism, intellectual disabilities, physical disabilities, and some women had multiple impairments. And in terms of types of violence, I'm not going to spend too much time on that, but just to kind of briefly list, it starts, some of the women chose to speak to me from about violence from early childhood all the way to the time of the interview. And so it reflects the continuation of violence and the multi-types of them, which included starting from bullying at school to system violence to physical violence, some just general physical violence, other physical violence related to the disability, sexual harassment, forced abortion, forced sterilization, all the way to rape. For some of the women had a combination of different types of violence. And in terms of perpetrators, we have friends, family members, partners with and without disabilities. You have the service providers, you have staff at services, you have immigration services and police abroad. You might also notice that on the top part of the graph, out of the 18 women, only 3 reported. Now, 2 reported to the police and the third one reported to the rights protector officers. And I just want to briefly say, so the first woman under the pseudonym of Mary, who reported first, told her mother, and together they went to the police, and subsequently a rights protector was involved, and the case ended up in court and actually in a positive outcome. And that has been my first publication, the link of which I'll talk about in a second. And then, as I said, the third woman also reported to the rights protector officers instead of the police, because they had observations, like many other disabled women, about potentially not being believed because of being a foreigner and having multiple disabilities and so on. So if you move to the next slide, please. So here, as I said, the Mary's court case has been my first publication. And in this slide, I provide the title and the link under the triangle there. So the title of this paper is "We Got Lucky with a Judge, Access to Justice for Disabled Women in Iceland." And I think that the quote, "We got lucky from a judge," was said by Mary's lawyer. And I think that speaks volume, and that's why I chose it. Access to justice should not depend on luck. And what the lawyer is referring there is the fact that the judge was willing to accommodate Mary to provide reasonable and procedural accommodation. But again, that is not the focus of today's presentation, but I'm happy to answer to that. My second publication, which is the focus of today, is on the rights, the role of the rights protection officers. And this article was just published this September. And again, here is the title and the link of it. The title is "They Guarantee Understanding Both Ways, Rights Protection Officers as Facilitators of Access to Justice for Disabled Women." Now, the quote, "They guarantee understanding both ways," it is said by a police, and we'll come to that in a moment, why and how. But if you move on to the next slide, please. So if I was to summarize the role of rights protector officers, or maybe before I do that, I should say, so rights protector officers are professional allies. They're established by law in Iceland. So the Act on the Protection and the Rights of Disabled People 2011 covers their role. They're a type, in my article, I argue that they're a type of independent statutory advocacy scheme, but they are part of the ministry that covers people with disability. And, recently there has been some amendments, including them more in terms of the penal code and Code of Criminal Procedure, through the back door in a way, but listing them as a type of support person that a disabled person can bring either at the police statement or in court. But if I was to briefly summarize the role of rights protector officers with regards only to access to justice, because they have other roles too, but in their mandate, they specifically refer to Article 13 of CRPD, so access to justice, and Article 12 on legal capacity. So if I was to summarize the role, I would say that it will be a threefold, and this is what I argue in my article, that first and foremost, they are there to support the disabled person. Now, I must say, even though my research focuses on victim survivors of gender-based violence, the rights protector officers also support perpetrators with disabilities. So no matter which side of court you are, you will get support. And if a case involves a disabled person as a perpetrator and as a survivor, there is different rights protector officers supporting each. And then the second part of their role is to request reasonable and procedural accommodation. And third part is to advise justice workers what, why, and how to provide these procedural accommodations. And so it's threefold. It goes together all the time, but sometimes the confusion of justice workers is that they forget that the primary role of rights protector officers is to support the disabled person first and foremost. And of course, like every other structure or support service, there is limitations to their role, but I can briefly mention that. So please, in the next slide. So in this slide, I have tried to capture the journey of a disabled person, a disabled woman going through the justice system. I know there's different figurines, but bear with me, I'll explain. So, and capturing the role of rights protector officers. So if you remember the threefold, the triangle, that threefold role goes throughout the different stages of the justice system. So in the figurine, you have or in the image, you have a figurine of a woman, and I do capture here like 6 barriers to access to justice that a disabled person faces, starting with disclosing. That is a hard thing to do. And I have had women in my research who talk about 10 years going by, 20 years going by before they actually disclosed their experienced violence to anyone. So we should not undermine that it is a barrier, be it self-barrier, but we need to find the person we trust. Now, the option here in the figurine, in the image that I put is, of course, the disabled woman can go directly to the police or tell someone. They can also go, according to the law, they can go to the rights protector officers and report there. So there is these different arrows going there, and the 112 is the police and the emergency phone number in Iceland. And then from there on, the next gate is from reporting to the police into the case, going to the investigation, reflected here with jigsaw pieces. So we need all the jigsaw pieces to form the case. And in order for it to go to the prosecution, reflected here with a weighing scale, that because the prosecutors I interviewed talked about, if they see the case more likely to win, they send it to court. But if they see that there's missing evidence or that it won't win, they will drop it. And then the next gate will be for the case, to go to court. And from there on, the last gate is for it to end in a positive outcome for the disabled person. Now, the reason why I went through those gates is to highlight that the role of rights protector officer is to facilitate overcoming these barriers. So if we go back to the police, when you are there, for example, in Mary's case, the rights protector officer advised and requested that the police will give Mary extra time to process the question asked and then to answer, ask them to invite Mary to answer questions and to describe things in her own words rather than giving leading questions. The police statement was not taken at the police station, but rather at a different facility called Bjarkalíf, which is a family justice center here in Reykjavik, and where you can also go and report if for any reason you have a fear of a police station. Other types of accommodation that the rights protector officers have highlighted to me is the police officer not being in uniform because the disabled person is scared of police officers and so on. In terms of the prosecution stage, particularly when cases are dropped, the rights protector officers are invited again together with the disabled person, and that is to explain in the most accessible to the person the reason why the case is being dropped, and also to offer the person the option or the chance to ask questions why the case is being dropped, or to appeal such decision to further authorities. In terms of the court, again, the rights protector officers have a key role to play there, but different to the other stages in court, their voice has to go through the victim's lawyer or through the prosecutor to the judge to ask for extra or to ask for reasonable or procedural accommodation. Again, more time was provided to Mary in her case. There was a microphone provided because she has low tone to her voice. And I mentioned that, particularly the microphone being brought, because I interviewed some people, some justice workers, and they responded to me, "It's okay, we'll just ask the person to speak louder." The irony on that and the misunderstanding that is not a volume button you put to your voice, not for everyone. Anyway, so I want to highlight all of this, and if you move to the next slide, please. So here I have included some quotes from the rights protector officers and the police. I won't read all of them, I'll talk around them. So prior to 2022, when there was some amendments to the Code of Criminal Procedure, as the rights protector officer says here, it depends on each police officer whether their role was accepted or not. So we had cases where the rights protector officer was kicked out from the police statement because the police believed they had no right to be there. Now, this has changed. Again, as I said, there is some amendments where that states that a disabled person has a right to a support person, and the accompanying bill of these amendments lists rights protector officers particularly as the ideal support person, and at the police stage and in court. And as the rights protector officer explains here, is that the process usually starts by police or the individual calling them in case of violence. The police calls them and invites them to be part. The rights protector officer is calling it here investigation. So the police statement practically to support the disabled person and to advise and request what supports are needed in order to make the experience more easy on the person, but also to make their voice heard. Now,
Eliona, we have about 2 more minutes.
I'm almost finished. So, and on the other side, we have quotes from a police officer who talks about respecting the role of rights protector officers, while highlighting that sometimes so-called victim lawyers lack disability-based rights training, and most of the times they can't understand their own client. And beside the disabled person, the rights protector officer is the most important person, and that they this police person respected the fact that they are there to support the police officer, also to give the opportunity to the disabled person to have their voice heard. And as he put it, we are respecting each other's field. So it's not one educating the other, it's respecting and making sure that the disabled person has the right support to have their voice heard. And as I said, it was a police officer who said that the rights protector officers guarantee understanding both ways. By that, he meant that the disabled person will understand what the police is saying, and the police will understand what the disabled person is saying. So to some extent, they are in some parts similar to intermediary, but their role is beyond that. So on that note, next slide, please. I will leave you with a quote from Mary's article. My argument that access to justice should depend on systematic protection, not luck, happenstance, or something else, individual will to provide accommodation. So thank you.
Thank you so much, Eliona, and to all three of our speakers. I think perhaps we have 1 or 2 minutes for questions, if anyone has questions. I think a microphone will reach you in a moment. We have a question from the floor. If you could just introduce yourself and the person you're directing your question to.
And I'm Giampiero Lupo from the National Research Council of Italy, and my question is for Eliona. I'm sorry if Eliona. Yeah, sorry. Yeah. I was wondering why you consider the action of the prosecutor that decides whether going to court or not on the basis of the possibility that the case can be won, a barrier and not simply a sort of filter, which is executed in, I think, for everyone. Yeah. And I consider, for instance, the Italian case where you don't have only the filter of the prosecutor, but you have also a judge that is deciding also for the initiation of the investigation. And then you have also another judge that will decide if the case goes to court or not. So you have many filters. And the idea is not to have cases that have not substance to go to court and have too much burden on the system. Thank you.
Yeah, should I answer to that? Or?
Yes, please, Eliona, go ahead if you have.
Okay. Well, of course, I agree with you. There is prosecution rules that every case has to be, I guess, judged in such criteria that there has to have a higher percentage of potential winning. Otherwise, the case won't go to court. But the reason why I put it there, and this particularly affect most people with intellectual disability and communication barriers. And I'd say barriers because the reasonable and procedural accommodations aren't put there, is that the prosecutors I interviewed said that when it comes to cases involving disabled people, we look at the evidence and we just think that maybe this person won't be able to restate their statement in a coherent way in court, and therefore that becomes the major factor for dropping the case. And I don't think that applies to non-disabled people. Generally, so I think it's a kind of a discriminatory attitude rather than a procedure, because it's not written anywhere, and I am a strong believer that if the police statement and if there is proper, reasonable and procedural accommodation provided, that we have the right to speak in whatever way we do. I mean, no victim of gender-based violence or any type of other violence can keep coherent to their statement, and we have to remember that, you know, you might go to report today and 2 or 3 years might go by before you actually have your case in court, and the idea of stating everything with every comma and full stop that you stated 3 years before, it's absurd to me. And we had cases like that here in Iceland, that no reasonable accommodation was provided at all. For example, in Mary's case, the rights protector officer insisted that Mary sees the courtroom before the court hearing, and that had a major impact, because compared to another case in few years before, this wasn't allowed, and therefore when the woman was in court, she couldn't focus on her own statement, but instead commented on the lights and on the noise and on the pictures in the walls and stuff like that. So she was distracted. If she had been familiar with the courtroom, I think the outcome of that court case would have been completely different. So I hope that answers your question.
Yeah, thank you very much.
Thank you, Eliona. Do we have any other questions, either from the audience or from our online participants? Okay, I think that it just leaves it for me to thank our 3 speakers again for a really stimulating and interesting session. And I have been asked to give you a 10-minute coffee break, and then we need to be back, so I won't keep you from your coffee anymore. Thank you, everyone.